We'll give him a couple more minutes. So how is everyone doing this evening? Everybody's muted.
Good.
Doing well, doing very well.
Good. Well, I'm glad you guys could join us this evening. If Chester signs on, I'm sure it will be very informative. We were given permission to record the session, so if there's anybody you know that won't be able to join us tonight, they'll be able to listen in. I don't know if you guys saw the email as well as, I don't know if it's come out in the newsletter. Anyone who has Benton PUD as their electrical service, they've launched a COVID-19 customer assistance program. Qualified customers who certify they've been impacted by COVID will receive a one-time bill credit up to $200, et cetera, et cetera. So there's information on that. We can send that out again, but it was sent out by email to everyone, so you should have received that. If you have any questions, you can contact me and I can email you the information. It's a very short period of time, though. The program is going to end July 31st. So if you know of any tenants that need assistance with their electrical service, or if you're responsible for the electrical service, take advantage of that program if PUD is your provider. Are there any other questions or comments from anyone this evening?
Hey, Jody, I talked to Nicholas Yuva today about the landlord mitigation fund.
Yeah.
Everybody there's hoping that within the next couple of weeks, go to their website and watch. It'll be the, what do you call it? The landlord COVID-19 relief fund. And that'll be where you can access rental assistance through the landlord mitigation fund. So it should be coming together in the next couple of weeks.
Good. Okay, because I know that they hadn't set the platform up yet. They were waiting on who was going to be funding it and that kind of program and how much it was going to be. So last I'd heard, they hadn't had that set up yet. So, okay, still working on it. Good. Is there any other information from anyone? Are you guys having luck getting rental assistance from any other programs out there? Guess not.
Hey, Jody, there have been some questions about the, this is Steve Goheen, some questions about the lease or the rental form.
Yes.
You might want to talk about that. We have a disclaimer on the website now that we put on recently, but things are changing, so we're trying to catch up with all the changes in the law.
Yes, what he's talking about, for those who are unfamiliar, we've kind of put a pause on selling any forms at this time. I mean, if you insist that you want a form, I guess that's your choice. I know people are trying to sign contracts. Olivia in the office called me yesterday wanting to know, a gal had come in wanting to purchase a rental contract, and I didn't really know what to tell her, because until we have the language, I hate to have anybody sign a contract with what we currently have, because it's going to be obsolete. So if you're looking to purchase forms, hopefully Chester will join us tonight and give us a little insight and guidance on that, on what we can do. But I strongly urge you not to make any large purchases, certainly, until we revise those forms. I know Rob Trickler with WLA is working hard on getting that out. And as soon as he puts something out, we will copy his forms and make them available to all of you. So,
excuse me, Jody, Rob did make an updated rental contract. Is 14 pages long, so but it is up to date. He has a date of 5/21 at the bottom of his new revised rental contract, so that could be used.
Oh, okay.
And it can be accessed through our BROA website, but we're going to try to come up with one that's a little bit shorter as well. But
okay.
In the meantime, they can use the WLA form.
And that's already been loaded on the website?
It is not loaded on our website, but there is a link from our website to the WLA website.
Okay, okay. I will let Olivia know that. So is that for single family residence or multifamily? Do you happen to know?
I think it might apply to both, but it's certainly it'll apply to single family.
Okay.
I didn't look at it that carefully, but it's lengthy.
Yeah, 14 pages. Yeah. Well, that's lawyer speak for you, but that's kind of the situation that we find ourselves in. So I don't know that we can, that I'm not real eager to edit it down too awful much. We'll have to take a look at it and see. There might be something we can whittle out of it, but for the most part, I think every time that we edit his forms, we make ourselves liable for that. So I don't know. Donna Smith, do you have Chester Baldwin's phone number?
Maybe.
We'll
have to look.
Yeah, could you guys try to get a hold of him? Maybe he forgot. I sent him the link on Tuesday, and he responded that he'd be here, but I don't have a whole lot to say if he doesn't join us. And this is the meeting we really need him to weigh in on. So,
Okay, we're looking.
okay.
He's on, Donna. We didn't do that, but it looks like he's on.
Oh, he joined us. Okay. All right. Michael Britton made the comment that the WLA landlord website has the form section password protected. I believe that the password was sent out earlier. It's 2302 is the last one that I had. If that's not current, someone please correct me and let me know. And then the question is the moratorium ending for sure? Well, there's nothing for sure. I think the state one will be ending June 30th, but then, you know, who knows about the federal CDC one. So we'll see. I will let Mr. Baldwin address that. So. All right. Good evening, Chester. Thank you for joining us.
Hey, good evening. Thank you guys so much for having me.
Well, I'm going to let you have the floor because I know that you have a lot of information to share and talk about. So.
Wonderful. Thank you so much. And would you mind if I shared my screen?
Yeah, absolutely.
Oh, wonderful. I've got access now, so I'm all good. In just a second, I'm going to put up just a summary of a couple bills that I think we want to talk about. But before we do, let's talk about just sort of where we stand politically and the background on which all of these things in Olympia happened this year. Because we're going to talk specifically about Senate Bill 5160 and House Bill 1236. We'll talk about a few other things, but those are two of the biggest bills that happened this year and two of the very biggest things that have happened in rental housing in a number of years. So let's talk about those things. But to get into that, our legislature has a House that is controlled by Democrats, and they have a 16-seat majority in the House. And we have a Senate that is also controlled by Democrats, but that is a 28-21 majority. So there are 4 moderate Democrats, and those 4 moderate Democrats sometimes align with their Democratic counterparts, and sometimes they align with Republicans to make sure that bad things don't happen to housing. And that was the case with rent control. Now, we beat the rent control bill again this year. We are the only state on the West Coast that does not have rent control now. Now, we don't want it. We're not looking for it. And we were able to keep it at bay again this year. And it's going to be back again next year. So we'll talk about that bill just a little bit as well. That's Senate Bill 5139. But let's go ahead and hop into these. I'm going to pull this up. And I'll send over a copy of this whole report so that you don't have to write any of these things down. And I'm going to run through the first few bills pretty quickly. The first one, there's a property tax deferral that you're able to apply with your county for. It's up to a year of no interest or penalties on that. We passed a tax increment financing bill that we had run several times before and have never gotten through. We passed the multifamily tax exemption bill. This was a really good piece of legislation that we did a lot of work on as well. House Bill 1083 is a manufactured housing communities bill, not so much apropos to us. And then we get to some of the stuff that we opposed. The first of those being Senate Bill 5160. So the original version of Senate Bill 5160 extended the governor's eviction moratorium for 2 more years. So if that version had passed, we would have, whenever the governor ends his emergency, we'd have another 2 years of eviction moratorium where you could not evict anyone on top of that. So that bill also said that your tenant could live in your unit from the time that and could never pay rent for COVID from March of last year through June of this year, never pay $1 of that rent, and you could never do anything to evict that person. That was in the original bill as well. Those things are gone. So this is a bill we did a lot of work on and were able to make some significant changes to. So now instead of having a 2-year extension to the governor's moratorium, I'm going to scroll down a little bit, this bill was amended several times. So it got better and better and better for us. So first we removed the 2 years and the part that said tenants could just live in our unit and not pay rent. Then we increased the landlord mitigation fund from $5,000 to $15,000 per tenancy. So we have a requirement in the bill to provide a payment plan. And so if you do provide a payment plan and your tenant does not make good on that payment plan, or they vacate the premises without paying, you can apply to the landlord mitigation fund to be reimbursed up to $15,000 per tenancy now. So that was a really big deal for us. We also removed the Consumer Protection Act violation in the bill and the penalty that was 4.5 times the rent. We removed a requirement that you would have had to send notice to the Housing Justice Project every time you give a 14-day notice. And then we even worked with lawmakers to get an end date to the eviction moratorium. So that now, according to the bill 5160, ends on June 30th, 2021. That's a big, big deal for us in getting an end date, and one that lawmakers came together from both sides of the aisle to say, okay, we agree June 30th is the end. And we had a few concerns that the governor might choose to extend it beyond that date in opposition to the legislature. But I spoke with the governor's office yesterday, and they've said that they have no plans to extend the moratorium beyond June 30th. So, you know, I'm not telling you to take that as gospel truth, but directly from the governor's office yesterday, we asked the question, and they told us that they do not plan to extend the eviction moratorium. So there were 2 sections of this bill that were vetoed by the governor. There was one section that would have provided rental assistance in counties outside of the emergency rental assistance program. And so let me go back. This bill also created a program by which in these 6 counties, the pilot program counties, Snohomish County, King County, Pierce County, Thurston County, Clark County, and Spokane County, before you can move forward with an unlawful detainer after COVID is over, even in addition to having the requirement that you provide a payment plan, before you can move to an eviction, you have to go through dispute resolution with the dispute resolution centers. And there is money that they can institute directly through that process to pay the tenant's rent to the housing provider on their behalf. So that's part of the bill as well. The section that got vetoed by the governor is really disappointing, though, because places like Benton, Franklin County, and some of our eastern Washington counties, we would have been eligible, every low-income tenant would have been eligible to have their rent paid by this program if the governor had not vetoed that section. So this is a big deal to us. And then he also vetoed another section that we had $7.5 million in rental assistance for tenants who were affected by coronavirus but did not otherwise qualify for rental assistance. And the governor vetoed that money as well. So any questions on Senate Bill 5160 before we move on to the Just Cause bill?
Does that increase in for the landlord mitigation fund from 5,000 to 15,000? Does that only apply to low-income residents or others who just didn't pay rent?
Great question. So the landlord mitigation fund, usually, you're exactly right, Jody, that only applied if we had somebody who came in on a subsidy. That was the only way to access that money. That has been changed. So you can still access it that same way as historically when you have a tenant who came in on a subsidy. It is now also available for anyone who has to offer their tenant a payment plan as a backup if that person does not pay the payment plan. or if they vacate the premises during the, let's say you put them on an 18-month payment plan, because your payment plan now has to be 1/3 of you have to give them 3 months for every month of rent that they owe. So if they owe 3 months of rent, they get a 9-month payment plan. If they owe 6 months of rent, they'd get an 18-month payment plan. So many of us believe that people are going to skip out on those payment plans and not finish through and just vacate the premises. And if they do that, they do not have to be low income or subsidized in any other way. If they do that, you are eligible to go to the Landlord Mitigation Fund for up to $15,000 per tenancy. So that was an important one for us.
Okay, good.
Any other questions on that? Okay, then I am going to put the screen back up and we're going to hop into Senate Bill 1236 or House Bill 1236, because that's the other really big bill. Let's see if I can do this. Okay, can you all see that? So House Bill 1236 has been called Just Cause. We like to call it the mandatory lease renewal bill. This is a policy that has existed in Seattle and a few other places for more than 20 years. And basically what Just Cause means is, even if a tenant is on a month-to-month lease, you can't end that lease just by giving a 20-day notice like we normally would. Instead, you can only end their lease and terminate that tenancy if it's for one of these listed reasons. And this Just Cause bill, I believe, has 16 different listed reasons that you could terminate a tenancy for. But what the bill says is that all tenants who are on month-to-month tenancies are entitled to just cause. And that means they can live in your unit for as long as they choose, so long as they don't violate one of those 16 things. And some of those conditions are, you know, if they don't pay rent, you can still terminate them. If they don't abide by the rules, you can still terminate them. But it does limit your ability to end their tenancy if it's not for one of those reasons. And so this bill would have applied to all tenancies. We were able to get this modified in the Senate so that there is still a path for housing providers who want to be outside of just cause and don't want to have that apply to them. So let's talk about a new tenant, and then we'll talk about an existing tenant, because there's a little bit of difference. If you were to have a new tenant, this bill says that if you give them at least a 1-year lease up front and then renewals of 6 months or longer, you can give 60 days notice before the end of any one of those rental agreement terms. So at the end of the 1 year, at the end of 6 months after that, the end of 6 months after that, or, you know, you could give them 1-year leases. At the end of each of those terms, you can choose to end that tenancy by giving 60 days notice. That 60 days notice is new, but that at least is a way to be outside of just cause. Now let's talk about current tenants. For a current tenant, if they've ever been on month to month, after this, we've got a little bit of a period. So the bill gives us 90 days after the end of the eviction moratorium. So if the eviction moratorium ends on June 30th, which we believe it will, 90 days after that would take us to September 30th. So what the bill says is if you want to be outside of the just cause protections, you have a 90-day window from June 30th to September 30th to get your tenants onto a lease. And even if they have previously been on month to month and would have had just cause protections, if you get them onto a lease that's at least a year long up front, in that time period before June 30th, it will be as if you've always had them on a fixed term lease, and therefore you can end their tenancy at the end of the term of that lease or any of their lease extensions. But again, if that person ever ends up on a month-to-month tenancy, they are then entitled to just cause protections. And that's what the poison pill that's referenced in this document. It's that if somebody's ever been on a month-to-month tenancy at any time, that you can never be outside of just cause. And so that person's always entitled to just cause. So that's House Bill 1236. And that was signed by the governor on May 10th, I believe. So has gone into effect and is law, as well as 5160 also becoming law.
So you have the 90 days, you have to get them on a 12-month lease up front before September 30th or before June 30th?
Between June 30th and September 30th.
Okay.
So 90 days after the June 30th date, because the June 30th date is the end of the eviction moratorium.
Right. Okay.
According to the bill.
Okay. Thank you.
Absolutely. So I very strongly encourage our housing providers to think about getting their tenants onto a lease in that time frame, so that you will not have just cause apply to you. It's, you know, just cause is not the end of the world, but it does loosen our control and make it so that we can't determine when we want our unit back or when we want to end a tenancy. You don't have that control anymore under just cause. It has to be for one of those listed reasons. Now, one of the listed reasons, I believe it's letter K in the bill. It covers this. So I've gotten the question, what happens if I give somebody a lease, say June 30th, after the June 30th date, and they refuse to sign it? Well, as long as you give it to them at least 30 days before that time period, at least before June or September 30th. So if you give them a lease by September 1st, if they choose not to sign that, that is one of the just causes, and you could choose to end their tenancy based on their failure to sign that lease after being given at least 30 days notice. Okay, one more thing I want to hit specifically. So, should be right here. So Senate Bill 5139 right here. This was the rent control bill. We killed that bill this year and did it with the help of 4 moderate Democrats and all of the Republicans in the Senate. This bill is automatically alive next year, so we're going to have to fight rent control again next year, and we're going to need all of your help. And it has been amazing to see some of the members from BROA that have been part of testifying at the legislature or signing in opposition to bills. The one good thing about the coronavirus and this Zoom environment is it's easier for people to be involved in the legislative session than it's ever been before. You know, we really owe a ton of gratitude to the minority party in the Senate. And we are a bipartisan organization. We support Republicans, we support Democrats, but let's be very clear. The Republicans have our back every time on housing issues. They're there for us. And, you know, if it weren't for those 4 moderate Democrats that we have that come over and side with the Republicans, we would be in a lot more trouble. We would have rent control right now if it weren't for all of the Republicans and those 4 moderate Democrats. So we need to say a huge thank you to especially our Eastern Washington lawmakers. They are saving the day time and again for us. But I can't tell you how much it's meant to see many of you involved in Olympia, whether it's signing in on a bill or testifying or coming to one of the information sessions or meeting with a lawmaker on Zoom with us. I see at least 5 or 6 people on this call who I know have participated in those things. So just a huge thank you to you guys, because it's the grassroots efforts that we have at the Washington Landlord Association, and that means all of you. It is that makes a difference. And we really, you know, we got 1,000 people to sign up in opposition to Senator Cooter's bill when it had a 2-year extension to the governor's moratorium. And that's because people like you got involved. And that's the reason that we were as successful as we are, that and the strong support that we have from our lawmakers who understand what we're doing and are fantastic. So you guys just need to know how great your lawmakers are in specific. And they are always there helping on housing issues and having a backstop for us. So if you get the opportunity, please reach out to your senator or your 2 House members and just say thank you, because they are always strong for us. And I really appreciate your area when we get to Olympia. Any questions about that?
I had a couple come in here. How do you find tenants to skip out with no forwarding address? Perhaps that's not a question you can address.
Yeah, I mean, I think that's an answer. You know, you need an attorney and maybe even a collection agency that does some skip tracing who can help you with that. But if you've already set them up on a payment plan and then they skip out, you can use the fact that they've skipped out and you've already offered them a reasonable payment plan as a reason to be able to collect from the Landlord Mitigation Fund. And so if that does happen to you, I'm really sorry, but the legislature has looked and tried to make this a little easier. So they've created a fund that will help pay some of that if you've gotten them on a payment plan already.
And then the form that lists the 16 reasons for just cause, are you going to be sharing that with us or?
Yeah, that will come out through the Washington Landlord Association. Okay. I know Rob has done a ton of work on that and is getting those ready, so they'll be on the website and available to everybody. And I think there's actually, to make it, I don't want to say idiot-proof, but to help make sure that we're using the forms right, I believe he's actually created 16 different forms one for each of the different just causes, so that way you just figure out which just cause it is that you believe you have, and you use that particular form. So that's going to be a really big benefit for our members as well.
Okay, yes. All right. I don't see any other questions at this time.
Okay, then the one other thing I'd love to just give you guys a quick update on, if I could, is the capital gains tax, because I think this is important. There we go. So this was Senate Bill 5096 was the capital gains bill, and it puts a 7% state capital gains on all long-term assets starting January 1, 2022. So it doesn't go into effect for another year, or most of another year. It also has an exemption for the first $250,000 in state capital gains. All taxpayers who have any capital gains are required to file their return with the Department of Revenue. And this bill does contain an exemption for a family-owned small business. So if your business did less than $10 million in annual revenue the previous year and you sell it, you are exempt from paying capital gains on the sale of that business. It doesn't have to be in real estate, it can be any kind of business. Then in addition to that small business exemption, the other thing that's in this bill is an exemption for all real estate. So this was a huge win for us. Now, we don't like capital gains. We don't support the capital gains tax bill. We think this is an income tax, not an excise tax. We think it's unconstitutional. There's already been a group that's filed a lawsuit on it, and there will probably be an initiative to the people on this. But all of that being said, our first goal was to get real estate exempt from capital gains. And your lawmakers did that as well. So it doesn't matter if you own a single family home, a duplex, a triplex, an entire apartment complex, commercial office buildings, doesn't matter what kind of real estate, all real estate is exempt from capital gains. The only exception to that is publicly traded shares of real estate investment trusts, REITs. If it's a publicly traded REIT, they're going to treat that like a publicly traded stock. And the reason we were able to get real estate exempt from capital gains makes sense. It's because we pay property tax every year, and we pay the highest real estate excise tax in the country other than New York when we sell. So we're already paying our fair share of tax. And, stocks are not paying those same things. They're not paying property taxes every year, and they don't have a real estate excise tax when you sell them. And so that's where this is targeted at. Doesn't mean we think it's a good policy. We think an income tax is still completely unconstitutional. But our first goal was to make sure real estate was not subject to that. And your lawmakers helped us get that done. Questions?
I had a question on a previous topic. It says, we are not in one of the counties that you mentioned for the landlord mitigation fund. Can we still access those funds?
Yes. Every county has rental assistance funds. The thing that's different about those counties that are outside of the 6 pilot program counties, you are not required to go through the dispute resolution center and jump through all of those hoops before you're allowed to file an unlawful detainer. But you do still have access to rental assistance money because it's being divvied up to every county. So you should check in with your county on, and I think it is not out in the market yet from what I understand, but it's very close. There's even some counties taking applications for the rental assistance money. And I think it's like $360 million in rental assistance money that's coming out. So talk to your county about that because that will be coming out directly from each county. So even if you're in a county that's not part of that pilot program, there will still be rental assistance in that county. You just won't have the same requirements to go through a dispute resolution center on your way to filing an unlawful detainer if you get to there.
Okay, thank you.
I have a question, Chester.
Yeah.
I was reading through the Bill 5160. If you've offered a repayment program, a plan to a resident, they default on it, and you go after the writ of restitution, you go to evict, and you get the writ, are you no longer allowed to then access the landlord mitigation fund to? Yes.
Yep, that's correct. If you choose to go with the route of getting a writ and moving the tenant out, you can't then you can't apply for the landlord mitigation fund for that money to be made whole in tenancy. It's only if if the tenancy is going to continue or if the tenant vacates willingly, not through an unlawful detainer action.
So if the tenant just willingly goes, all right, I'm going to go because you're going, hey, we're going to file for the writ, and they voluntarily go, then you can go after the landlord mitigation?
Yes. Yep, you sure can.
Ask your question.
Judy, was there a question there?
Yes.
Dale here. I have a couple questions. With the governor signing this new law, does that render our existing rental agreements invalid, or are they still
Yes.
enforced? Do we still have to abide by them?
Well, you still have to abide by them, but the term that's rendered moot is the part that ends the lease. So you don't have the ability to end that lease unless it fits under the exception to just cause. But the rest of that lease is still in effect. So the terms, if you've got your rules and policies and procedures, all that stuff, everything else in the lease is still in place. It's just that if you don't meet the qualifications for just cause, your lease may not be able to terminate, even if it says it terminates.
So what type of notice does the renter have to give us if they decide to leave? Is that still
20 days? Yep, it sure is. How fair is that?
Yeah. Then if we bring a new lease or bring a 1-year lease to a tenant where we have an agreement with them that's month to month, and we're going to change that out to a 1-year lease, the month to month agreement we have with them now talks about refunding the what do they call that?
Fees. Yeah, deposit fees.
The initial deposit. And it talks about having to do a condition report where we look at those items on there where we had looked at them and filed that away. They agreed that this was a condition, everything. Do we have to go through that process before we give them this new lease if they're going to stay there? And
that's more of a personal choice. If a lot of landlords want to have a walkthrough to see the condition of things if they're going to sign another 1-year lease with somebody, but there's nothing in the law that says you have to do that. And so you would be able to, and you're talking about entering into a new lease during that 90-day safe harbor period.
yes.
Is that right?
Yeah. So if we do that, do we give them back their original deposit or whatever portion of that they pursue? We decide that we need to give them back, and then have them on the new lease give us a new deposit?
There's no reason you can't roll their deposit from one over to the other as long as it's agreed to by the parties.
So we can write that or somehow have an agreement where that they agree that that's what we'll do if we agree with it as well. And that doesn't cause us not to have a new agreement with them, a 1-year term as opposed to month to month.
Right, because as long as you're giving them a lease with a 1-year term, then yes.
Thank you.
Okay, I got a couple of other questions here. Back to Kevin Glenn's question, if writ done, tenant moves, is it now small claims to get the lost rent and damages?
Yeah, I think that's probably one of your best. You're looking at filing a legal action one way or another in order to do that. Some people choose to go the collection agency route. That's another choice. But yeah, you're one of those two for the most part if you're already to there.
Okay, and then how do you enter a new lease when you have to give 60 days rent increase notice, but only 90 days to get on a lease?
Great question. So what I think a lot of landlords are choosing to do is to start to send a notice to their tenants to let them know that they're going to be entering into a discussion on new lease terms. And so you don't want to give a rent increase during the governor's moratorium. So until June 30th, you don't want to do that. And so what a lot of people are going to be doing is come July 1st, they're going to be sending out a notice that says, come September 1st, 60 days later, your new rent is going to be this, and we're offering you this lease. If you don't accept that lease on this day, June 1st, we will be terminating your tenancy. And if you do that, you've complied all around with the different sides of that. You've given 60 days notice for your rent increase. You've let them know now that you're going to be giving them, offering them a fixed term lease. And you also, fixed term lease, yeah, and so you've complied with your requirements under the statute, and you've done it in a timely manner. So I think we're going to be advising all of our housing providers as of July 1st, if they want to be outside of just cause, they need to give a notice to their tenant to let them know, hey, we want to negotiate with you on a new lease agreement. And if we can't reach an agreement on that by, September 1st, we will not be renewing your tenancy. And that way you've complied all around. And that is one of the 16 exceptions to just cause, is that you've offered a lease at least 30 days in advance and the person chose not to take it. And so that would be the way to comply with that. And the Washington Landlord Association is working on forms for that, for you all to use as well.
Hey, Chester, in Bill 5160, it talks about when you offer a repayment plan, there's 14 days for the resident to accept, or the tenant, excuse me, to accept it. And then from the point of when it's offered, it's 30 days that it can take effect. My question is, when can we start doing repayment plans? Can we start them now, or do we have to wait till June 30th or like July 1st till the?
No, you can do it now. Payment plans you can absolutely enter into those things now. And since 5160 has passed, it put into place kind of the sideboards for what a reasonable payment plan is. It says you have to offer, a third of a month or 3 months for every month of rent owed. So if you're in line with that, there's no reason you can't start now with talking about, payment plans and working those things out with tenants.
So, and if
you can't threaten to evict them if they don't work that out with you right now, because until June 30th, you can't say that.
Okay, so it's not till June 30th to where you can say that they've got the 14 days to accept it, or you can go after the writ. That you can't do that until after June 30th, correct?
Right, because there are no evictions before June 30th.
So do you say it'd probably be almost wise to then on July 1st offer the repayment plan that gives them 14 days? That way you can go after the writ at that point in time. Because if you do it now, I mean, would that even come to effect? If you'd offered it now, they haven't accepted it. They say we offer it today, and then by July 1st, they haven't accepted it. Would that still constitute the whole 14-day thing?
Yeah, it's just at least 14 days. So you could give more if you choose to. So if you wanted to use the analogy you just laid out, you'd be just fine if you did that earlier.
Okay, I have another question here. We should get new leases after June 30th, even if the current lease is only a few months old, and they'll need to do that or be evicted at the end of the first lease.
So it gets a little bit complicated with current tenants. So if we're talking about current tenants so most current tenants, because the eviction moratorium has been in place and we haven't been able to give new leases, most tenants are not on a lease right now. And so because the bill was written the way that it was, what it says is if you were on a month-to-month tenancy on May 10th, then everything that I just told you is true. If you were not on a month-to-month tenancy as of May 10th, then it's going to depend on whether you've always had a lease or whether you were on a month-to-month tenancy previously. Because what the law says, unfortunately, and this is a donut hole. This is a place that we tried to address with lawmakers. We knew this was a potential problem, and what they said was, how many tenants? Most everyone is on a month-to-month tenancy right now. How many tenants are going to be on a fixed-term lease that's going to go longer than the time period during the end of COVID and that weren't on a fixed-term lease since the beginning of their tenancy? And so if you have a tenant, though, who was on a fixed-term tenancy on May 10th, and that tenant was on a month-to-month tenancy sometime in the past, my belief is that tenant is entitled to just cause. And I don't think there's much we can do as housing providers about that. Now, that doesn't mean that's not the end of the world. Just keep in mind that if it's a good tenant and somebody you've had good relationships working with, it means that tenant, it means you can't end that tenant's tenancy, but it doesn't mean they're going to go to being a terrible tenant. It just means you don't have control of that unit until you have a new tenant in there, most likely.
It's very confusing.
I know this is confusing, and that's why there's going to be a bunch of forms coming out from the Washington Landlord Association to help people. I think it's not only confusing, I think the law is written poorly, and I actually think the bill conflicts with itself in a couple of places. And so as attorneys, we're trying to figure out how to work through that because it's really, really poorly written. Especially the section about this 90-day safe harbor.
Okay, people, do you have any other questions? Now's the time to ask them. I don't see any more. So evidently you answered everyone's questions. So all of those
Well,
forms
thank
that,
you for having me.
yeah, thank
Oh,
you
go ahead.
so much. Well, I was just wondering, you will, can you email me all those, that summary of bills that you had so we can put in our newsletter and share with our members?
I sure can.
Okay.
Jody,
Well,
we have one more question. please.
okay, go ahead.
Oh, yeah.
Dale here again. In listening to you talk, it sounded like during this moratorium that new leases could not be entered into or changes could not be made to existing leases. Is that correct?
Well, you could not change the lease or increase the rent on the lease. And so most housing providers didn't want to enter into a new long-term lease without being able to change those rates. And because the governor's moratorium does not allow you to increase rent, most housing providers decided not to offer new rental agreements to people who they could not choose to increase rent for.
But you could have offered an amendment to a one-term or a one-year lease that you had out there that came due during the moratorium and give them another one-year lease with no rent increase. Would have that been acceptable?
Yep. If you didn't increase the rent, you were okay. You could do that.
Thank you.
Can you write it up that, so like people who are turning over and trying to sign new contracts now, they should go with a term, a 12-month lease, correct?
On the first one, on your first lease, you want to go with the 12-month term so that after that, you can use any lease term between 6 months and 12 months or 6 months or longer, and you're okay. Now, just remember, if you use a lease that's longer than 12 months, you have to get it notarized and you're subject to the statute of frauds. That's why most people use 12-month leases or less. So on that first lease, what the law says is it has to be 12 months or more. Just remember, if you're going to be more than 12, there's that extra requirement.
Sure. Okay. All right. Are there any other questions? All right. Well, thank you so much, Chester. It's always informative listening to you, and my goodness, you had your work cut out for you this year. So
Well, we couldn't have done it without everyone's help. So thank you all for participating. Thank you guys for being willing to contact your lawmakers, to reach out and to be involved in Olympia. We couldn't do this without you guys, and you guys are amazing.
all right. Well, thank you very much. We're glad you're on our side. So you have a good evening. Okay. Thank you.
Thanks, you too. Bye, everybody.
Bye-bye.